the Supreme Court of the United States will review Illinois' National Guard deployment case. Welcome to Law and Society. I want to briefly talk to you about this. So, the Supreme Court of the United States has limited jurisdiction over cases. The Supreme Court can't take up cases without them coming to the lower court first. The lower court has general fact-finding jurisdiction. When Illinois drafted the complaint and filed the complaint, they asked the district court, Judge Perry, for a temporary restraining order based on the facts and based on the fact that they are likely to succeed on the merits that the Illinois Guard deployment in Illinois by Donald Trump federalizing the National Guard is violative, does not meet the requirements set by the statute that Donald Trump picked, which is 10 U.S.C. 12406. Well, the Supreme Court has narrowed the scope of the inquiry that it's going to take. There was an amicus brief filed by Professor Martin Lederman, who is a scholar and an expert in constitutional law when it comes to military affairs. And Mr. Lederman has filed a friend of the court brief telling the court that under 12406 section 3 that requires the use of regular forces refers to armed forces of the United States, and because that precondition of deploying the armed forces or the inquiry that the president is unable with the regular forces to execute the laws of the United States means that Donald Trump did not meet the threshold requirement for 12406 section 3 to apply and for the National Guard to be called up. So it is a different argument than the states' rights argument. It's a different argument than what the Solicitor General, the government itself, has argued. And this is sort of a technical argument of statutory interpretation where Professor Lederman says that throughout American history, the word regular forces has been used by Congress and by the government to mean the armed forces of the United States. Now, obviously, and Mr. Lederman points out in his brief, it brings up the question of bringing in troops into domestic civilian situations that would violate the Posse Comitatus Act unless there is specific legislation that allows for the troops to come in. And so 12406.3 says that only in the case where regular forces, meaning regular armed forces, are unable to carry out the duties as prescribed by to execute the laws of the United States, the government has not met the threshold requirement of 12406.3 because of the historic meaning of the phrase regular forces. So the Supreme Court sort of picked up on that. And the Supreme Court, the question the Supreme Court is asking both the government and Illinois to answer is whether the term regular forces refers to regular forces of the United States military, and if so, how that interpretation affects the operation of 10 U.S.C. 12406.3. And so, if you were to agree with Professor Lederman's argument that regular forces meant armed forces, then it is impossible under the statute to call on the National Guard when there has been no showing of whether regular forces were able to or unable to execute the laws of the United States, because Donald Trump didn't call in the regular army in this situation. Furthermore, the Solicitor General in the case has confirmed that the regular forces to which the president referred in his memorandum are personnel working within civilian federal law enforcement agencies, that is, ICE and other entities within DHS, including the Federal Protective Service. It is highly uncommon, however, to refer to such civilian officials and employees as any kind of forces at all. And they certainly are not regular forces to which 124063 refers. The regular forces to which the statute refers are instead the standing military of the armed forces within the Department of Defense. That is the crux of Professor Lederman's argument, and the Supreme Court seems to have taken that question up of whether regular forces mean armed forces, and if they do mean armed forces, then how does that impact Section 3 of 12406, which says that only when the president is unable by the use of the regular forces to execute the laws of the United States, may he then call upon the Federal Service of the National Guard through the order to federalize them to be issued through the governors of the state or the commanding general of the National Guard in D.C. So it is a different argument, and we're going to see what both the parties have to say and what the argument is, because the Solicitor General's whole premise on bringing up 12406.3 as the authority for deploying the National Guard to Illinois does not, according to the amicus brief, satisfy the statute 12406.3. And therefore, you don't even have to go into any of the other factual findings. First of all, if you do go into the factual finding that the United States had been invaded or in danger of invasion under Section 1 of 12406, you can prove that that is not the case. You know, the state is likely to succeed on the merits that there was no danger of invasion. The state of Illinois is likely to succeed on Section 2 of 12406, saying that there's no rebellion or danger of a rebellion against the authority of the United States. And so it rests on Section 3 of the president being unable, with the regular forces to execute the law of the United States, for the president to invoke this law to then federalize the national service. But according to this amicus brief argument, regular forces mean the armed forces of the United States, and if it means the armed forces of the United States, then the Solicitor General's argument falls apart, because according to American law and history, regular forces have always referred to the armed forces of our military as opposed to the civilian federal enforcement agencies that are under DHS. We're going to see what the ruling is going to be. I think the parties have until November 10th or something of that sort, mid-November, to file their briefs, and then there's going to be a date set for oral arguments, and I'm going to be listening to the oral arguments because it is a very narrow question that the Supreme Court has honed down upon by essentially just throwing out all of the other questions. Because if the president has not satisfied the letter of the statute, that means he doesn't have the authority to deploy the National Guard under 12406. And the court seems to be leaning towards the fact that we are going to look at the definition of what regular forces mean and then determine the applicability of this law, of whether the president is even allowed to invoke this law and bring in the armed forces into Illinois and then ask for federal service in light of the Posse Comitatus Act. So it has to be reviewed to see whether the Posse Comitatus Act's exceptions are 12406.3, if it qualifies as an exception. If it does qualify as an exception, Donald Trump hasn't deployed the regular forces, and therefore he doesn't meet the requirement of 12406.3. With that said, I hope I've not confused you, and I hope that you keep an eye on this, because this will have major implications when the Supreme Court rules on the applicability of 12406 generally, and specifically 12406.3. With that said, thank you so much for listening. Please like, share, and subscribe. Take care of one another, and I will talk to you soon.